frequently asked questions. In this video, I'll answer 5 questions about immigration over random immigration topics. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. TPS, dual citizenship. Can I apply for TPS when I have a dual citizenship? The answer is yes, but under what citizenship am I supposed to claim TPS? So the way this one works, let's say Haiti, for example, has been designated for TPS recently, and you have a dual citizenship because with Haiti, there is an amendment that was made, I believe in 2012, and now people can have dual citizenship. So let's say you have a citizenship from Haiti and you have a citizenship from Honduras, or let's say you have a citizenship for a country that hasn't been designated for TPS. Let's say you have Haiti and you have Congo, for example, okay, because Congo has never been designated for TPS. So now you hold 2 citizenship. Which one are you going to claim? Well, of course, you're going to claim the Haiti citizenship, but now the question is, are they going to accept it? Because remember, you have 2 citizenship. The way this one again works is that they will go over the one that they call operative citizenship, basically the one that you claim when you enter into the United States. When you got into the United States, what passport did you use? Did you use the Haitian passport or did you use the Congolese passport? Let's say you came to the US and you used the Congolese passport, and now Haiti has been designated for TPS, while now you want to claim Haiti so that you can get TPS benefit. Unfortunately, they are going to go with your operative citizenship, the one that you claim when you enter into the US. So it's really going to be difficult for you to claim TPS under Haiti when you have been using a different citizenship since you enter in the US. There's some exception to it. Some people have been able to claim with their dual citizenship another citizenship because those people, some of them enter without permission, enter without inspection. So basically, when you enter without inspection, while really you didn't claim anything, you just enter, and then later on, Haiti, for example, again becomes a TPS designated country. While now you can claim Haiti because you enter without inspection. So there's no way for them to know what operative citizenship have you been operating under. So that's about it. TPS. Okay, let's go to the second question. Fraud waiver with marriage. Am I going to be able to get a waiver based on a fraudulent marriage? This is very complicated. The answer is it depends. Well, first of all, we have to know that waiver is discretionary. They can waive if they want to waive. But when it comes to fraud marriage, this is almost like an unwaivable offense. But why? Because the way fraud works, basically the way will corner you down. I've talked about it before. The way they work, they will say that, well, you are prevented from subsequent petitions. So let's say one petition was declared fraudulent, based marriage fraud, sham marriage, and then you want to claim another petition, maybe under your child. Of course, they bring back that 24C, I believe, paragraph and say, well, you are prohibited because of subsequent petition cannot no longer be approved regardless. So some people, of course, what they do is if they find themselves in removal proceedings, then they can use another form of waiver in order to gain withholding of removal based on the fact that extreme hardship on the children, and perhaps at that point they might stay only under withholding of removal, pretty much so, because when it comes to fraudulent marriage, it is very difficult to win a waiver on any level. But in removal proceedings, there could be a possibility, but again, very limited. Okay, let's move on to question number 3. Question number 3. Someone asked, what is the difference between filing for religious worker petition under R1 and filing for religious petition under I-360? There is a major difference. Let's say you're inside of the US. Well, of course, when somebody's inside of the US, really they want to go with I-360 so that they can adjust status later. But the I-360 works better if you already worked for that religious organization, because once that I-360 get approved, then you can adjust status. So you have to have at least 2 years of experience working for that religious organization. Otherwise, well, the best course of action will be getting a visa first, the R1 visa, and work for 2 years for that religious organization, then later on file I-360, and then later on adjust status. Okay, let's go with the last question. No, the fourth question. Fourth question is, well, what about the bill? My friend, we already know that what's next when it comes to this budget reconciliation bill, the immigration bill that was inserted into the budget reconciliation. We just have to wait for the next step. The next step is that legislators will be drafting this proposal in terms of how is basically giving us guidance on what they want to see exactly, but they have to draft it in a way that it is showing some type of fiscal point, not regulatory point, because it is budget. So they have to convince the parliamentarian that, well, immigration does fit into budget reconciliation, because one of the arguments is that it's going to raise revenue. How? Because when people are going to get, when the bill will become law, then people must apply to get those paperwork, or to get that temporary protected status, or that legal status, or that green card. And at that point, they have to pay USCIS fees, and they have to pay on top of it penalties for unlawful presence or any other inadmissibility issues. So in that sense, it is going to raise revenue. And then because it's going to raise revenue, that's why it fits into the budget. Okay? So last question, adjustment of status. Well, the question goes like this: how are they going to determine whether by the time I file for adjustment of status, I am admissible? So first of all, they look at on the date, right? Remember that you apply for adjustment of status, they have to find you admissible in order for you to change status. So by the time you file your application, you have to ask yourself those two questions. Am I lawfully present? Or do I have a valid non-immigrant visa on the date that I am applying for adjustment of status? Let's say that you get in the US with a visitor visa, and then later on you get married, maybe 4 months later. And then on the 5th month, remember visitor visa, 6 months, then even if it's multiple entries, you have to go back out and come back in order for those terms of the visa to be really valid. So let's say, again, back to the example, let's say you get married, right? On the 4th month of being here, and then on your 5th month, you file for paperwork, including adjustment of status. Well, on the date they receive the application, you are on your 5th month. Basically, you still have your non-immigrant visa valid. At that point, when adjustment of status get there, well, you are admissible unless you have other inadmissibility issues like public charge, health, and all that. But if it's only about lawful presence, then at that point you are lawfully present by the time you apply. That goes too with F1 visa. When your visa is still valid and you apply for adjustment of status, then you are admissible. But if your visa is not valid and now you're applying for adjustment of status, there are a couple exceptions, right? When it comes to marriage, well, that one gets forgiven. When it comes to if you are protected under the grandfather clause, that one too gets forgiven. If you were, let's say, a VAWA petitioner, unlawful presence too gets forgiven. But you really have to know the specifics in order for you to evaluate and know for sure whether you are admissible to adjust status. Of course, there is a cure to it. Sometimes it works, sometimes it doesn't. Waiver. Sometimes it works, sometimes it doesn't. It just depends on the argument, depend on their own discretion. Remember, waivers are discretionary. So those were those 5 questions, okay? We have answered those 5 questions for you. If you want me to answer other questions, please go ahead and comment below. If you want a consultation with me, please call 202-751-2180. Email on display. Consultation fees apply. Well, until next time, bye-bye.